Welcome back. Just before the break, we were talking about root cause. Was telling about. She actually asked a question, and the break came in, and I say after the break we'll go to address that question, and we can talk a little more about that. And your question, can you repeat that question again so that the audience knows?
Let's say that the person is stuck at the U.S. Embassy.
Right.
It's been several months, and now that client comes to me and asks me, I have a new employer, can I just refile and file a new H-1B petition?
Right.
And I'll get the new visa and I'll come to the U.S.
I would say yes or no, more on no part, because that case that is pending under section 221G, they call admin processing, which is probably file given to FPU, the
Yes.
Fraud Prevention Unit. So let us say that actually there's a fraud on the part of the applicant. So they are looking at his fraud. So it doesn't matter you have a second or a third petition. They want to clear that first. Did he commit any fraud or misrepresentation? Or this was strictly a problem with that employer only. So if they have any kind of slightest thing, but they won't do it as a practical matter.
They
want
won't.
to clear that.
Yes.
They want to clear that. Then after clearing, if they find out that nothing wrong on the part of this applicant, it was the employer, then they say, okay, you forget about that employer because there's a problem case there. This employer is good. Your H-1 petition is valid. Go ahead, we'll issue the visa. That's the answer.
Let's say that there is a problem with the petition. What happens then?
Yeah, then depends on what kind of problem it is. It is to the level where they will do 6C, fraud or misrepresentation, or some hanky-panky maybe not coming to that level. The definition of fraud misrepresentation reaches to the level where that.
But if they do not like something, they usually do return.
Yeah, they return the petition. That's a separate issue.
Yeah.
They return the petition back to Immigration Service
Yes.
for a review or revocation.
Yes.
They call it. But generally they say review.
Yeah.
In that paperwork it says the council is looking more at a revocation. What happens then? The Immigration Service will send a notice of intention to revoke. Like they are telling the petitioner employer that we want to cancel this because this is what you did. However, we are giving you 30 days time to submit anything, any rebuttal that you have, so that we can take a look at that. And if then the employer gives them that information and they are satisfied that seems like counsel was wrong and this person should be granted, they will reapprove that petition, return to the council, and then the council can.
I have to say that I did have a case once where the consular officer, after reapproval, they sent it back again.
Yes.
They didn't like it.
Sometimes it happens. No, not only that. I had a couple of cases where they did re-investigation again.
Yes.
They thought that they don't understand, that Immigration Service don't know what we know. So they re-investigate and then tell the USCIS that please look at this case carefully. These are the facts.
Yes.
And you again tell us, still you want us? At that time USCIS says, oh, seems like counsel is right. And then they revoke the petition. So, I mean, see, the thing we have always been talking about, that you always should go to a lawyer or a law firm that has a lot of experience, understand from A to Z, how the system works, what the process takes place. Repeatedly we are, saying people, I mean, believe me, we've been doing program for 39 years on this and other TV stations, 39 years. I have never said, you come to me. I don't say come to me. I say go to a lawyer who's well experienced. In other words, I'm not the only good lawyer in the world. There are other lawyers too. But I'm not saying that I'm the only one, or you come to me, or some people advertise on that, or they say come to me, come to me, come to me. Any good lawyer, make sure he's ethical.
And licensed. Licensed attorney.
Yeah.
That's important.
Experience, he got experience, he's ethical, and that's the attorney you want. He can work well with you and the employer. There are so many factors to be taken into consideration. So you make a decision.
Yeah, that's correct.
Okay, so I think we should start the other part of the this other subject, enough for the H-1Bs. But if you have any questions on what we talked in the last program and this program on H-1B visas, feel free to contact us, send us an email, and we'll be more than happy to give you any additional information, guidance, and whatever is needed. So remember, when we started the program, Lutka, we said we probably will be talking about those two types of visas where the consul, even if he has denied 3 times visitor visa or 4 times a student visa, as long as there is no fraud or misrepresentation in the previous applications, consul will not deny your H or L. So now it's a time for L now. We just did about pretty much well with the H1s. So L1. And L1 I believe is L1B and L1A.
That's correct.
Let's talk about
L1A, it's for applicants with in managerial or executive role, and L1B, it's for somebody with specialized knowledge of a product or a services of the company. That's very important.
Right.
Not any specialized knowledge, but some type of advanced knowledge of companies, products, services, information of the company. Now, as far as the...
So you're saying L1B is for specialized knowledge?
Yes, that's correct.
He doesn't have to be a manager or executive or anything?
That's L1B.
L1B.
L1A, it's for somebody in managerial role. So it's somebody who is managing department or a function or managing people.
Right, correct.
Yes.
So the requirement is that person who's coming from India, who's looking for an L1, he must have at least 1 year of experience
one full continuous.
In the last 3 years.
Yes.
And people say, oh, in that 1 year, could he have traveled? Yes, but they will deduct that period. So with the 1 year period, he has only 1 year experience, which qualifies him. But in that 1 year period, he was 3 times here and spent 4 months in US. Then he has to wait 4 more months.
Yeah, because the rule is it has to be 1 year continuous years. That's very important.
But it could be different, but it has to total add up the 1 year period.
Exactly.
And he's coming here to work for a subsidiary, same company or affiliate company,
branch,
in the same position, in a managerial position.
Exactly.
Right? So that's a very good start, and we got a lot to talk about L1 visas. Once again, it's time for a short break, and right after the break, we will continue the rest of the time that we have today. We'll talk about L1 visas and L2s, who are the spouses or children of the L1s. So stay tuned. We will be back.